Scott Hemphill, who is a professor at New York University. Scott, the floor is yours.
Terrific. So first, thanks for the opportunity to join you all. I want to go, I think fair to say, in a somewhat different direction from Commissioner Wilson and also from Professor Crane. I don't plan to spend much time on the topic that was raised a few moments ago of innovation in NYU's antitrust program, other than to celebrate the arrival of a new colleague, Daniel Francis, who will start at NYU this summer as a newly minted professor. I think I see him on the attendee list. My honest guess is that Richard probably replaces me with Daniel next year in as many ways as he can, but we'll see what he thinks once I finish my remarks. So I want to explore, and I know this is a false choice. We could both show up on the same dance card. I want to explore one of the many issues raised by the conference in its framing, namely rulemaking, or maybe slightly softer ex ante rule selection by an agency, which is not exactly the same thing, but is a subset of it, I suppose. Conference describes this, I think, as a, I'm quoting, transformational shift from ex post judicial enforcement towards ex ante regulatory rules, and with the result that, quote, we're taking away antitrust from the courts via preemptive regulations rather than via subsequent prosecutions. And so my goal with this half hour we have together is to think about some of the pros and cons of ex ante regulatory rules established by an agency as compared to ex post adjudication by a court. Now, disclosure here, I've done some consulting work on rulemaking in the residential real estate area on behalf of Rex, which is a startup that's interested in disrupting the NAR status quo in this area. But for avoidance of doubt here, I'm only speaking for myself. So I think I understand the framing of the conference correctly to be negative or hostile to an ex ante or agency-oriented approach. I might be overreading it, and in any event, I'm more positive about this development and want to offer a few reasons why to kind of get the conversation started. So I think three here are particularly important. First, ex ante rule selection by an agency helps to set a big picture rule that relies on relevant facts that are not easily considered in a single case, though sometimes necessary to consider. Second, and I think fairly standard or straightforward, if done correctly, rulemaking leverages deep expertise in issues where a journalist court might be led astray. And then third, finally, depending, of course, on the content of the rule, this sort of thing might provide some helpful certainty to private actors. Now, I think these benefits are actually illustrated by one important area where we already rely on ex ante agency work, namely the horizontal merger guidelines, right? The HMG, most recently revised in 2010, sets itself out to, quote, describe the principal analytical techniques and the main types of evidence on which the agencies usually rely to predict whether a horizontal merger may substantially lessen competition. I think that's a fair description of what they actually do. We have detailed and I would say rigorous, I mean, perhaps in some ways incomplete, but detailed and rigorous explanations of how the agencies think about these difficult problems, and which implicitly provides advice to courts about how to do it. I think that rigor is useful. I think the guidelines have been helpful. I think they illustrate some of the strengths I just mentioned a minute ago. They provide a big picture perspective that relies on learnings from multiple cases, whether it's an empirical regularity or experience with forms of analysis that have been fruitful, or I suppose the ones that are omitted that have turned out to be analytical dead ends. They leverage deep expertise earned over decades of work, and they think they provide a measure of certainty to private actors, although one's mileage may vary depending on the facts that you're trying to make sense of. So I think other agency guidelines, which I recognize have some differences from full-on rulemaking, but that share the characteristics that I want to emphasize, have perhaps been similarly helpful. So let me now take each of these 3 points in just a little bit more detail. So first, on this question of getting the big picture right, I think it's important to remember, what are the strengths, but also potentially some limits of adjudication. Adjudication works, I think, particularly well at establishing ground truth on particular facts, also in reasoning by analogy. But of course, antitrust decision makers, and this isn't like every area of law, but I think it's especially important in antitrust, or the decision makers are often called on to do something else, to set some kind of big picture rule that minimizes error costs across a wide range of cases. What they are being asked to do is the ex ante selection of a rule in the rules versus standards kind of sense. So courts are already doing this. They're already doing some ex ante work. Predatory pricing was mentioned earlier today. In predatory pricing, as either most or everybody on this call knows, the Supreme Court set a two-part rule. Predator must have set a price below cost and needs to show a likelihood of recoupment. And the Supreme Court laid down this confining rule because it thought that that would minimize error costs because of a concern about false positives, and in reliance on what it thought it knew about the distribution of conduct. Now, I think courts are not ideally suited to doing this kind of work. The error costs of a particular rule aren't going to be apparent from one set of facts. You need to know something about the distribution, and courts are not necessarily going to have the necessary information. They may be forced to make guesses based on some academic article that they happen to have ready to hand, or an amicus brief by folks that are, of course, motivated to tell just one part of the story. And so I think we end up with bad rules set by courts some of the time. I think predatory pricing is probably an example that are premised on, for example, the mistaken idea that predatory pricing is rarely tried and even more rarely successful, or even the not established idea, right? That I don't think that's been shown. So on this first point, I think rulemaking offers some promise as a way of handling error costs because it takes in a broader set of inputs. Second, this question of expertise. I'm just going to focus on the Federal Trade Commission here because I think that's where the practical action is right now. The FTC knows a lot about some areas. Delayed entry by generics in the pharmaceutical industry is, I think, a fair example. I think it'd be helpful to have an expert agency like the FTC put down markers that could aid courts in wrestling with highly technical issues. I'm not proposing, just to be clear, a pay for delay rule. I think, 10 years ago, that would have been the thing for us to think about, but I think that's perhaps less urgent now. But, just to think about issues the courts have struggled with over the last few years, in the context of one of these reverse payment cases, does the payment have to take the form of cash? Well, I think if you accept the Supreme Court's rule back in 2013, then the only fair understanding is that it includes not only cash, but other forms of value, and that it's economically senseless to make a distinction between cash and other forms. Nevertheless, some district courts got this wrong in the early years of consideration of reverse payments. There's lots of little issues like this that you could imagine an agency being quite helpful on, given their superior technical expertise over time. Now, I want to just emphasize here that I think it's important that this be done with rigor and that it can be done with rigor. I would not myself favor a regulatory process that ignored the economics. The point rather is to use the economics in a way that the FTC is capable of doing, and in fact to build up the economics using the FTC's superior fact-finding process. I mean, the whole point, I think, really is to provide a fact base that's attentive to these effects. So I'll just give a real estate I've had on the brain. So let me just offer a real estate example. Suppose the FTC did a deep dive into the residential real estate industry and identified particular trends or regularities, like, for example, commissions seem to cluster at 6% or 5.5%. This is a lot bigger than everywhere else in the world, suggesting that something is wrong or that it's not changed over time, again, suggesting something might be off. Identifies promising glimmers of competition, alternative business models that have causes that are then carefully explored and understood, identification of means by which protectors of the status quo might be setting up impediments to innovative business models. I could readily imagine a rule that helped improve contestability in such a market that was built from carefully earned expertise. And then finally, I just want to think a little bit about certainty. Setting rules, again, depending on the content of the rule, can provide useful certainty, which we to private parties, which I think we all rightly think of as being a positive value on the margin. Here, I want to take as my example, this may be an example that people find disruptive rather than soothing. Take as my example, Section 5 of the FTC Act, a statute that I think we all understand from authoritative Supreme Court construal, expressly goes beyond the bounds of the Sherman Act, but which in turn raises questions about what that extra breadth should contain. And here I think the FTC could do some useful work in helping fill out what's missing. That is, conduct that is harmful to competition, though not squarely captured by the recognized boundaries of the Sherman Act. So, I could imagine harmful actions by a firm without a showing of either agreement, as Section 1 needs, or monopoly power, as Section 2 typically needs. Harmful actions that we still think are at antitrust's core. I mean, invitation to collude is an easy toy example that probably people would broadly agree on, but deception, adoption of a facilitating practice, one could think of as being very much in the heartland as understood by economics, and yet not within the Sherman Act. I think this kind of thinking is important for countering a kind of strange asymmetry, thinking now about the interplay of economics and law, which is antitrust has, I think, deeply internalized the use of economics as a shield for defendants. And I don't mean to be pejorative about that. I think that that's good and useful work. As an economist, I think I'd have my card revoked if I did not acknowledge the legitimate use of vertical contracts as a pro-competitive tool. And as a former Posner clerk, I think I have to sort of, to some degree, celebrate the transformation of vertical restraint law over the course of 30 or 40 years. But what we haven't seen, I think, is a comparable recognition of economics as a tool for identifying frustrating limits on Sherman Act liability, right? That we could have anti-competitive conduct that stopped short of agreement or stopped short of monopoly power that we'd want to do something about. And I think a full-throated embrace of economic rigor leads us to the conclusion that there are things that we ought to want to prohibit and that might plausibly fit within Section 5 of the FTC Act that have not been fully recognized. And so the thought here is just that rulemaking would offer, or ex-ante rule setting by the FTC in particular, would help provide that economically informed filling in of the gap in our collective understanding. So I'll stop there. I'm a couple minutes short of my 20 minutes, but that's fine.
Great. Thank you so much, Scott, for these explanations about how you see the dynamic between adjudications and regulations in antitrust. Richard, I see you have a...
Yeah, I want somebody else to talk, but absent that, let me sort of agree with Scott, or at least try to explain why it is on one point that we have to be concerned. You mentioned the NAR, right? That's the National Association of Real Estate Brokers or some such thing. And I actually did some work in this industry, and I have two sorts of responses to it. One is I think you're 100% right when you note that the cluster of rates and the absolute rigidity in this particular market is something which suggests that there's a strong degree of antitrust collusion. But then I want to talk about the second point. About 10 years ago, I had a client, one of the more interesting and difficult people I've ever worked with, who ran a technology company, and the purpose of his technology company was essentially to provide matching services that allowed for greater shall we say, cross-listing of things, which would bring more brokers into the market, which would induce a kind of competitive situation. And what happened is this fellow got himself a notice from some obscure official inside the Justice Department saying that he was now facilitating a cartel amongst various sorts of people when he was doing exactly the opposite thing. Just to make it worse, what they did in effect is they then sent the notice around to everybody who was one of his clients, telling them that they were also potential defendants in an antitrust case for participating in this sort of thing, which meant that he got precipitated with, shall we say, dozens of anguished calls by people wondering why they were potential felons. Then when you tried to use the system to figure out what was going on, it was almost impossible to figure out who was going to do this, because what happened in this particular case, this is an investigative action, and you didn't talk about him, so I'd like to hear your thoughts on it. The investigative action was taken by a single official. It didn't seem to have much clearance anywhere else coming from above it. And I've seen similar things happening with other companies that I've been involved with, DOJ investigations for security frauds and so forth. And the frightening thing about the actions as opposed to the policy, the moment you put an action like this in place, the company is no longer marketable and its services are no longer sustainable. And so how do these things resolve themselves? Well, in the one case, it was in bankruptcy because you could never right yourself, although there was never any follow-up by way of prosecution that the government gave. And in the other case, what we did is we managed to wait them out. Somebody else took over the office, looked at this particular complaint, and said, what the hell is this thing about? It's not that they revoked it. What they did is they simply never enforced it. And so to this day, we never got a clearance level. So the question I'm starting to ask is how it is, and I want to know the answer to this. I think you're surely right about some of the policy generalization, but how is it that we, A, make sure that any individual enforcement action is conformity with the policy, and B, how do we decide to give some kind of a check when in fact the threat of a government situation is a much more powerful threat against the company than some kind of private suit because of its ability to follow through with all sorts of other collateral relief. And I think, by the way, this is not meant to be, oh, I'm a Chicago guy kind of question, right? This is a, how do you run any kind of system of antitrust law when you have to worry about the question of delegated authority?
Yeah, great. So I don't know enough about the merits of the specific situation to say whether I agree or not that they shouldn't have been targeted. But let's just grant that for a minute, right? Okay. Let's take that, because I think that's the spirit of the idea. So my initial inclination is to think of this as an unexpected benefit of this kind of the ex-ante approach, of a kind of slower moving, because because it sounds like the context was an investigation with the threat of ex post enforcement. Yeah. I think of it as sort of a weird benefit, because I sort of think that that the slowness of a kind of rule selection process on an ex-ante basis would typically be a bug. It might be in your context a feature, because you're not going to have a single individual running a rulemaking, right? What I imagine typically happening is something kind of, to be a little bit jargony, sort of 6B study style, where the FTC would do a deep dive and really kind of understand something in a lot of depth. And so to the extent that one might be concerned about individuals just doing random stuff that or unfavorable or unpleasant or incorrect actions that that a larger group would see the fault in, I would think that an ex-ante approach, given the way that rulemaking would normally work, would help smooth over those rough edges and prevent some of that from happening. Just because it's a larger operation.
I don't disagree with that. The question really is, suppose they had put in some kind of policy which had announced that you're after horizontal restraints and you wish to encourage innovation, and at the level of generality. What they did in this case is they got it exactly backwards. You could take this on faith, I think, because it did eventually disappear. So what I want to know is, within the administrative state, how do we deal with the question of a delegated authority even after, right, we have put the rulemaking into place?
Yeah, I mean, I don't know if there's any easy answer there, right? I mean, folks are going to get stuff wrong, though, you know, in all states of the world, we're going to see
Mhm.
this, you're going to find this a small comfort, but in all states of the world, you're going to see some judicial review, right? I mean, we aren't and never will be at a situation where the agency can just sort of make it so. There's going to be review.
Mhm.
And so there's an opportunity to fix a mistake if a mistake occurs. I say this is called comfort because if you're talking about, I mean, I think it's well recognized that regulatory pressure may have its full effect whether or not it's ever adjudicated to conclusion, because you know the
Mhm.
the cold water splashed on some,
Mhm.
could be an innovator, might not be an innovator, but could be an innovator, could have its effect even before
Yeah.
personnel changes and fixes it, is in your example, or even more distantly, a court ultimately
Yeah.
rejects the regulatory push. I mean, this is obviously this is a problem for
For every system.
yeah, it's not just ex ante, it's not just ex post. It isn't even just government versus privates. I mean, uh, a private suit from an incumbent, you could have this effect. Although
No.
in antitrust, I'm not sure that's a first order
No,
problem.
I think the answer is the ability of the government to get preference in litigation and to have administrative remedies at its disposal and to have greater credibility means that there is some difference to it. Look, I don't know the answer to
I would
this.
add one more though, and I mean, and a lesser causation standard at the end of the
Yeah,
day, right?
yeah.
I mean, the
Mhm.
need to
Mhm.
decisively establish, let's imagine a price effect or something, is clearly not something that government has the burden for. So, I mean, relative to a private party seeking damages, I think the government has an additional leg up, which I think of as a feature in some contexts, but in
Bug in others.
in your framing of what happened in this particular instance, it might have been a bug.
Very, very difficult questions to answer. Daniel, you have a question?
Yeah. Hey, Scott. So you said at the end that there's been quite a bit of use of economic theories defensively to immunize firms from antitrust scrutiny, and you'd like to see more use of antitrust, of economics sort of affirmatively to create liability, if I understood you correctly. And I mean, that's certainly a narrative that one hears a lot. I think it's got to be wrong. I mean, the rule of per se legality for price fixing is based on economic observations about the harms of cartels. The use of the Hemphill-Hirschman index as a structural presumption is based upon economic views about when concentration becomes too harmful. Raising rivals cost theories of all kinds are based on economic theories about how firms can harm competition. So it seems to me that the whole structure, both liability and immunization from liability, is based on economic theories. And it may be true that like some economic theories have been wrong in favor of defendants, and at times some economic theories have been wrong in favor of plaintiffs. But I'm not sure. Do you really want to sort of feed the narrative that economic analysis has been the thing that's helped defendants and companies, as opposed to economics is what we do on both sides of the ledger?
Yeah. So let me start with the last thing you said. I definitely agree with the statement that economics is what we do on both sides of the ledger. And I also don't mean to suggest that economics has only been a shield, right? What I have, and I'll come back to your specific examples, I think, in just a minute. What I really mean to get at is I think economics has been a powerful tool in understanding what particular provisions of, let's say, the Sherman Act mean. And when it has done so, in the signal example for me being vertical restraints, it's been in a narrowing direction. And I'm not suggesting that kind of plaintiff side economics will necessarily result in a different understanding of restraint of trade, for example, right? Let's imagine economics proved that interdependence is that everyone must agree that certain forms of interdependence are anti-competitive, right? Certain forms of tacit collusion are identifiable and problematic. I'm not from there going and saying, oh, therefore we should define restraint of trade law to adhere to that. What I mean more is there is an opportunity, I think, with respect to Section 5 of the FTC Act to, and I don't even think of it as expanding liability exactly, but recognizing that certain kinds of economically problematic conduct could be reached under Section 5 of the FTC Act. So that's really the idea that I have there. I'm not sure one way or the other about the factual examples of HHI and the rule against price fixing as being economics successfully expanding the scope of liability. I think as to cartels, I think we do have an economic story for why the per se rule is a good one, but I don't think the per se rule itself was a consequence of careful work by economists. It's possible that you don't need careful work in order to understand the harms there. With respect to HHIs, it's a historical question for me. Which came first, Vaughn's Grocery or HHIs? My gut is that HHIs have turned out to be a disciplining tool that has not had the effect of expanding merger liability. But that's just at the limits of my knowledge. I don't know either way. But I definitely do want to agree that economics has been an important tool for plaintiffs. Maybe a better example for you than either of these would be activists in a sense. I mean, I think economic work was important in bringing courts, especially the Supreme Court, around to seeing how a probabilistic harm might have kind of concrete, even quantifiable effects on consumer welfare.
That was your work, Scott. Congratulations.
It was Carl Shapiro. It was a lot of people before it was me too. I mean, I'm part of that, but there's been a lot of people on that.
But just one point. So on the meaning of agreement, I mean, Don Turner was the one who pushed for a narrower meaning of agreement. This was not Chicago School economics, certainly. I mean, it was economically informed, and your old boss, Richard Posner, was pushing for a broader meaning of agreement from an economic perspective. So I don't know, I'd urge you to resist the story that Herbert Hovenkamp has often said that like antitrust law has always been based on economic theories. It's always been about theories of economics, and I resist the story that somehow law and economics has pushed antitrust to be all pro defendants. I just don't think that's historically right.
Yeah, and I don't mean to be heard as saying that. The thing I still want to hold on to though is if we think about if we think about shifts in the scope of, let's just stick with the Sherman Act. If we think about shifts in the scope of Sherman Act liability from since say 1970, the big ones that occur to me are the narrowing because of the narrowing on vertical restraint law, which I think of as being not necessarily the economics was super new, but it was sort of newly salient or further developed. And predatory pricing, where it was a particular economic understanding that I would say led to a narrowing, whether you think it was Brook Group or the cases that led up to Brook Group. But like I also, just to be clear, I don't think of economics as being an inherently pro defense tool. That's not my position at all, and I definitely don't. I don't think that is the case.
I think we have time. I think we're done. Orlin, do you want to make our grand announcement?
Yeah, so thank you very much, Scott. It was a very interesting discussion on you.